All right, welcome to the debt removal package, new for July 2017. And I want to go through each line of each step and make sure that no one's going to be making any mistakes with this. So, how to remove debt. Now, it's important to note, well, I'll just go through it. Let's just go through it. Debt removal package. Congratulations, you chose to have the most accurate method in existence to remove errant debt accounts. This is the debt removal package that is used for any and all debt except person to person debt. It does not work for person to person debts, but works for most other debts. That means that if there were, your neighbor gave you money, it doesn't work for that, okay? Very simple. It's just for banks, lenders, things like that on your credit report. All right? I hope that's clear. This is a step by step method to remove debt by inquiring correctly if a debt is in fact due by asking for proof in a way that if they cannot prove the debt is valid, then they actually owe you the entire amount and fines once you prove the debt is not valid. The best way to stop a bully liar is to ask them for proof of their claims and use their lack of proof to prove they are the ones in error and owe you. In order to give you the best information and ease of using the information, we will use an example of a debt collector called J.H. Portfolio Debt, and the person they're trying to collect this erroneous debt from is John McKeag. That's the example person in this example. There is a supporting video, i.e. this, that brings you through each part of the package. Click here for supporting video. So this is that video. Should there be something you want more clarification on, please write us an email at contact@libertyaid.org or contact@debtsavior.com or please write us an email at contact@debtsavior.com or should there be something you want more clarification on, just write us an email at contact@jackmckeag.com. Those other URLs may not be up yet, but the contact@libertyaid.org is up. Okay. Let's go to step one. All right. This is first mailing is a 4-part mailing. Okay, I'm going to go through the first part of the mailing, all right? And it's going to reference some other things. So you can see at the top there, settlement offer, right? And then the name of the person and the address and John McKeag. That's the name of the person and the person's address. Some people might call it your address, but that's incorrect because it's your person's address, your person's legal address. Okay? People aren't businesses, and so they don't have, they're not legal entities. People aren't. So they don't have legal addresses. Is this your, legal address? No, the person's do. Okay. So that's your top one is your person's legal address. Next is the debt collector, J.H. Port Debt in this example, and that's their legal address that they have. And it's what was their legal address. You might, it might in rare cases take a couple mailings. You're going to send this certified mail, right? And there's the date, and by a certified mail, you write the certified mail number down there. If you don't get a return receipt from your mailing, any mailing, you're going to have to change the address until you get, they sign for it, all right? And then there's the account number that they listed as their account number on the information that they sent. So let's go through the letter. If you cannot demonstrate validation of the debt within 30 days on the John McKeag credit report noted invalidation letter. So that's another part of this mailing. Included the notice in demand for payment, another part of the mailing, included is due. So in other words, that sentence is saying if you can't validate this debt, then the debt you claim is owed has harmed and injured your person on the credit report to the value they say they're collecting. So they owe you instead. Okay? In addition, no presentment of proof of license and or permit to regulate, issue, or collect on the promissory notes of the In God We Trust / USA Inc. has been demonstrated. See, if you look at a dollar, as most people call it, which is an erroneous name on purpose, then you'll notice that the In God We Trust, a business, and I say, and it says / USA Inc., which is a DBA. If you look up Dun & Bradstreet, on a Dun & Bradstreet search and look up In God We Trust, and put the state name in as Pennsylvania, you'll see the business pop up, the In God We Trust / USA Inc. And that is the name of the business that issues dollars, as most people call them, but they're really called Federal Reserve Note, a promissory note, or an IOU of the In God We Trust, which is run by trustees, and so no one's allowed to regulate, issue, or collect on these promissory notes unless they have been given license, contracted to in some way by the trust, by the trustees. And if they can't demonstrate it, well, then they're doing it illegally. And also because not many people notice, in fact, maybe I'm the first individual that has noticed, that those are simply trust notes. They're reluctant to take that information out into the public because it's such a great hoax and scam. So let's go on. The settlement offer gives two settlement options. And if an original is received within 30 days of a letter copied to John McKeag asking, let's fix this. Stating sorry, we had a typo in here. Oh my god. Stating thanks for your patience. Stating full satisfaction of this debt has been met, no further action is required on your part, and the fee due on the notice of demand for payment is waived. Okay, number one says, if you can validate this thing, wait, I'm sorry. My bad. We know they can't validate, so that's I'm sorry. If the original of the letter they sent to the debt collectors, right, having this thing removed, then we're going to waive the fee on your bill. Another name for a notice of demand for payment is what a lot of people use as a bill. You sent them a bill. You don't have to pay the bill if you get it off the credit report. That's what number one is saying. You don't pay the bill, the notice of demand for payment, if you send me a letter that shows you asked to have it removed from the credit report. Okay? Number two, you accept any and all actions will move forward to recoup the fine due on the notice of demand for payment included, on the notice of contract change included, and your lack of demonstration of the validation letter included for the inquiries. So see, this is a settlement offer. Remove the account, send us a letter that proved you asked for it to be removed, and then the problem goes away. If not, we're going to try and collect just like you're trying to collect. Okay, you with me? Good. All right, let's the next part of this mailing. The validation letter. They have to validate, okay? Now, same thing in the top there, send it certified mail. That's the account number they gave. Provide licensing and permitting information that proves you are legally allowed to collect on issue and or originate promissory notes of the In God We Trust USA Inc. from current trustee or trustees. If you're That was already explained, so you're asking them to validate that they have a license to do what they're doing. I've never seen one, so it's unlikely that they are going to have one. If you are unable to validate the debt, you agree John McCaig is a victim of identity fraud. This is important because they have stolen the identity of the person. They've stolen it, and they've put a derogatory mark on the credit report. So, John McCaig is a victim of identity fraud if they can't validate, if they don't have the paperwork, right? That proves the debt is valid, well then, that's identity fraud. There are many types of identity fraud. Go look it up on the internet. There are many types described. This is being a victim of identity fraud. Someone put a mark on the credit report without any proof. Okay. You are hereby in receipt of notice under the authority of the Fair Debt Collection Practices Act regarding your above referenced file number that part or all of the alleged debt is disputed, and hereby demand validation and verification in writing as follows. Signed contract. Really, this asks for all the things. This letter asks for all the things, and we're back down here to G. You have to have proof that your claim, that you can regulate. The In God We Trust notes, right? USA Inc. notes. A lot of laws are cited. A lot of time is going into putting in every little detail that they're supposed to provide in here. Okay, everything in here is in here that they're supposed to supply. So some people say, well, this doesn't exactly apply to my situation. A couple of these items may be only mortgage specific, but that's okay. It's okay to have a few extra items in here, right? Don't worry about that. There's your part in 8, it says in Florida, debt collector in Florida, all right? And for this one down here, it's on page before the last page, so I think that's the third page in the top, and 8, all right? You have to change that Florida there in the line to your state, where your person's legal address is. All right. So, and then we're asking. I'm gonna skip pretty much all that because it's self-explanatory. It's just a bunch of rules and laws that say why they have to, prove that they can collect on the debt. If they don't have the paperwork, they don't have the proof, they cannot collect. It's that simple. Copies are not good enough because you have to think about it. You could use a copy of the debt of a dollar bill to pay them if a copy is okay. And if they only have a copy, well, who has the original of the proof? If no one has the original, well, if someone comes along with a copy, someone could come with the original next week, and you have to pay it over and over and over. I know at the current moment, there are 3 debt collectors, 3 different companies trying to collect $19,000 from me. All 3 of them say that they have validated, and they're all claiming that I owe them each individually, 3 of them, the same exact debt. Doesn't make any sense. And so the only way to check to see if a debt is owed is to see who owns the paperwork, who physically has it, because they buy and sell debt all the time. All right, so you're gonna pay what, 10 people to come with a copy, 10 different companies? No, that's why you ask for proof. This is simply being good bookkeeper. All right, stay with me. All right, now let's get back down to the bottom of this thing. Please contact me in writing to arrange an appropriate point of inspection. Okay, fine, you don't want to send me the original. I understand that, but where can I go view it? You're trying to collect from me in Florida. I'll go somewhere in Florida. I'll go look at it. It says it right there. Litigation is very expensive for you and should be avoided at all costs. Should be an S there. Now there is. This is my good faith attempt to resolve this matter before I am forced to litigate and record notice of lien against JH Portdebt and its assets, starting with its corporate headquarters. I am pleading with you to resolve this matter privately and civilly as to avoid burdening our courts and county recorders with this matter. Pretty, I'm telling them. I just want to see the paperwork, right? Contacting me again after receipt of this notice will be providing procedurally proper validation without providing procedurally proper validation the alleged debt constituted a scheme of fraud by advancing a writing that you know or should know is false with the intention that the courts and or others rely on the written communication to impair or damage my credit rating, my reputation, my standing in the community, as well as intentionally inflicting financial and emotional harm upon me, which are all acts of domestic terrorism, which it really is. Has a 10-year prison sentence and a $1 million fine. I take this notice and my rights very seriously and expect the JH Portdebt to do the same. We can remove that period. See, if there's a period here or there, a little thing out of place, go ahead and fix it, all right? It's, this isn't, this is meant to be viewed and looked at, and you're getting this so you can change it, okay? In the event that this debt is not validated by you, as required by the Fair Debt Collection Practices Act, you have a legal responsibility to terminate the claim and correct any negative credit reporting which may have been made in connection with this alleged debt. You may want to obtain a legal opinion on this, but I believe that would constitute a scheme of fraud if this debt were to be resold, assuming that JH Portdebt has not, in fact, already sold the note it is trying to collect on, which would prove they had already been paid on the note they are trying to collect on. Yet another scheme of fraud the employees, owners, and auditors would all be personally and professionally liable for, individually and collectively, as a collusion for the reason of domestic terrorism. Just move for the reason. And collectively as collusion of domestic terrorism. There you go. I also will not respond to any future correspondence which is not signed or does not indicate who at your firm has sent the demand for payment. Failure to provide these items shall mean your admission that you have no claim and that your claim is proof of domestic terrorism. Okay, and this last bit's important. May our Lord Jesus Christ guide you in your choices as he does mine, as I surrender my soul, actions, thoughts, and all words and deeds to his authority under the Ecclesiastical Christian Ministries Trust, Federal EIN, that. Okay. I say to people, start with the common law irrevocable ecclesiastical trust first, and then go on to this debt work after. Use a non-taxable entity. This is the only one that exists. The trust available and Liberty Aid. Use that. Operate it. No longer operate the person and just have credit in your person. Okay, that's what I recommend. Look into the trust, but then, if you don't operate a person, if you don't hold assets there, if you don't take income there, if there's nothing there, then they can't counterclaim. There's nothing to get. So, and you want there always to be, there's nothing they can get. Only you can take from them by having excellent credit. Okay? That's what that last part is about. Sincerely, Minister John McCaig. See, the name of this is Christian Ministries, and so if you the word administer and minister are synonyms. So if you administer a trust, well, that makes you a minister, and so the name of the trust is Christian. That's the name of it. So that by definition makes John McKeag, the signer here, a Christian Ministries by definition. Okay. All right, we're on that part of the first mailing, right? This was the validation letter. Let's get on to the next part. Notice of contract change. This is an important one here because they allege they have a contract, all right? And they allege that their contract, if they produce anything, they will produce a copy, and they allege that that's okay to have a copy of a contract, a so-called copy, because what is a copy unless the original is sitting next to it? If the original is not sitting next to it, it's not a copy of anything. It's just a made-up thing on paper. That's why the original is all you're asking for, only always. It's like bringing a copy of a dollar bill. Well, here's a stack of copies of dollar bills. See, that's a debt instrument. That has to be an original, just like their debt instrument, right? The proof that they can collect debt must be an original. Has to be. It has to be, or someone else can be collecting on it in the future. Okay. So the allege a contract. I've gone to court many times, and they say, "Oh, well, a copy's fine." Oh, okay. Well, that's breaking the law. But let's say there is that is okay. That having a copy is okay. Well, then, this is a notice of the contract change. You see, if you're already in contract, you can change the contract with someone else if you don't hear back from them. They have 30 days, right, to do it. All right. So let's go through this notice of contract change. This is a 4-part mailing, okay, the first mailing, and this is the notice of contract change. Same at the top. Since there is a contract of creditor-debtor alleged from J.H. Port Debt on the John McKeag credit report, see validation letter included. We just went through that. This is a notice of contract change and termination of what contract of that contract with final terms to that contract for performance by J.H. Port Debt, and it is accepted that John McKeag need perform no further items in performance of alleged contract. If this notice remains unrebutted within 30 days of receipt, it becomes accepted. Final performance of contract requires J.H. Port Debt to pay in full. Notice and demand for payment included. Write John McKeag a letter within 30 days stating this debt is satisfied and will never be collected on again, and send an original of this letter to John McKeag. Okay. Contract change is, even though you can't produce that contract or can only produce a copy, we're changing the contract. You notice how if you have a credit card, they send you notice we're changing the terms of the contract. It just comes in the mail, and you can accept them or not, or close your card, whatever you want. So they allege they are in contract with your person somehow, right? So this is a notice of contract change. So it's changed. That's legal to do. They do it to us, so you do it to them. It's that simple. So let's check out the bill, the notice of demand for payment. Think of that as the bill you're sending them. That's the last part of the first mailing. Here it is. Notice and demand for payment, right? There we go. Same top, right? With the certified mail number in there. In the first mailing, all the certified mail numbers will be the same, okay? It'll all be the same. You're just sending it certified mail in one envelope, all right? Okay, so then notice and demand for payment. This is a bill to them. What is the bill? What's on the bill? What's on the bill is whatever they have on the credit report is the bill. At that amount, at that interest, that's what they owe, because they allege your person owes that. They put it on the credit report, yet they cannot validate it, so now they owe the bill. This is that bill. Since no validation of debt occurred for the alleged debt, you have harmed and injured the person, John McKay, to the value of the debt that is invalidated, $19,107.19 at 23.24% interest, and this notice is to recoup the debt you now owe and the $1,000 fine value for the SDCPA violation. That makes the total due upon receipt of $20,107.19. A notice of lien will be recorded against any and all assets, both personal and business, to recoup this amount due upon receipt, $20,107.19. Please remit payment not to the person John McCagg, as the person has taken a vow of poverty, but remit payment to Christian Ministries Trust, federally and blah. Explain that bottom part, but you see it's using words there that are very important that they use, okay? This is a notice of demand for payment. It's a collection method used by the IRS. You can go look up, you can Google notice of demand for payment IRS, and we'll explain that it uses this followed by a notice of lien to collect on their debts. So if the IRS can collect on debts this way, anyone else can collect on the debts this way. It's exactly the same. It's following a legal method. All right, and so your person, as is its religious freedom to do so, can take a vow of poverty and take no income, hold no assets, which it does. So it can never have any blowback. It can never. There's no point to anyone trying to get a judgment against an entity that has nothing and will never have anything, the person. And so that's why you operate a trust. Okay. Hope that explains the first mailing. All right. Now we're going to move on to the second mailing. Removal of errant accounts. Okay, this is the first mailing was to the creditors. This mailing is to the 3 credit reporting agencies. Okay, so it's 3 different pieces of mail going out to. It's 3 sets of mail here going out to, one to Equifax, one to Experian, one to TransUnion. The letters are exactly the same except for who's getting them, all right? And it says, there is an errant account on the credit report and it needs to be removed. Enclosed, please find the mailings to the errant creditor, what you mailed. The first mailing is what will be included in this. No validation response was received by the creditor, making the account automatically invalidated and proof of identity fraud. Okay, you already set that up in the first mailing, so you make a copy of that mailing and it's going to be included here. Also, enclosed, please find the police report reporting the identity fraud. Yes, it says that. It turns out, upon a lot of investigation, that identity fraud can be, a police report can be made and sent to the credit reporting agencies, and that will remove the errant file. So that is why you set up that first thing. In between these 2 mailings, before mailing this to the creditor, you sit down with the police, you call them, make a time, or go down there and set up a time for an identity fraud claim. Sorry. So they simply fill out the report. You have all the documents to prove you didn't get anything from them. They did not validate the account. So they have to remove it. By law, the account must be removed from the credit report. Please send an updated credit report with the outcome to this official dispute on the account. All right? You with me? Very simple here. Very, very simple. We don't like to make it complicated. Everything has gotten very simplified in my work. Removal of errant accounts, okay? And so it's a very simple letter, but it's going to have all the proof that they need to remove it. I've tried, you know, heavy persuasion on the credit reporting agencies, and the way I do with creditors in the first mailing, but it doesn't work. They don't respond to that favorably, and but they do respond to what's in this favorably. Okay. All right. Very good. Okay. So that's the second mailing, and it really is the exact same letter to the three credit reporting agencies. Okay? So we're going to move on to the third mailing. The third mailing is going to be to back to JH Portdebt, any alleged creditor, right? This is a final statement. You get final statements from you know companies all the time. Now you're sending a final statement. So the top is always the same. You get that certified mail number in there. Okay, let's go through this. Thank you for the information you sent regarding the account. This first paragraph right here that I'm going to go over, if they sent anything in return, this paragraph, if they responded to your first mailing, then this first paragraph will be in there. If they sent no response to your first mailing, this first paragraph is deleted. Just mark this all off, right? This whole thing right here. If they didn't send you anything in the mail in response to your validation, go right up here, click delete, and that's it. Okay, and the rest of the letter stands, all right? I'll put that back in. Okay, that's a simple thing, and then the rest of this, will be in here. But let's go over this first paragraph first. Thank you for the information you sent regarding the account. Enclosed is a copy of what was sent, and it shows a zero balance. Please send information as to when this zero balance account will be removed from the credit reports. What is this saying? If they sent anything to you, it was a copy. It wasn't an original, it was a copy. So simply make a copy of their copy, and wherever they put the amount due at the bottom, just put a zero in there. Copy and paste, cut out with scissors, put it in there, and put zero in where they have a balance, and make a copy of it. Why? Because you have a copy that says zero, they have a copy that, says it's a different amount. They're both so-called copies. Yeah, but where's the original? You see, if there's no original, copies have no meaning. And this proves, why not make a copy that's in favor of your person? Just say, no, this is what you sent me. You don't have to say you changed or anything. No, this is what you sent me. No, I made a copy of it. It's right here. You don't have to say you made any change or whatever, because, you can't really tell what comes out of a printer as a copy. Maybe it's exactly the same, maybe it's not. Why not, put the copy in your favor, and it is what they sent. It had maybe a minor change, but it's what they sent. So it's their word against your word against a copy, and you should never even be talking about copies. Simple, right? So this first paragraph forces them to produce an original. The validation letter was supposed to do that. They just sometimes don't even follow the law quite often. But this method helps them produce that original if they have it, which they never did. Okay, on to the next paragraph here, right? This is a final statement of your account. Please pay in full the amount due within 30 days or less to stop further collections that you agreed to in the last mailing you were sent. They agreed to pay by not disagreeing. Okay? Your first mailing, they agreed, unless they disagreed. Your prompt payment is appreciated. Please remit any payment. There you go. Explain that. So this is the final statement is the cover letter to the notice of lien, right? The notice of lien. Notice of lien right here. There you go. In the past, I've recommended doing UCC1, which is actually a notice of lien, but that's a complicated document. This is a very simple document, performs the same purpose. So Use this instead of a notice of a UCC1. No reason to go through all that rigmarole, really, because this is a recordable instrument right here. If it's not recordable, you may have to get this notarized. I would recommend uh, getting this notarized before you record it, which means you could simply make another one of these. All right, you could send them this one. If they respond to it, fine. Why go through the trouble of meeting with the notary and stuff like that if you don't have to yet? Maybe this step gets it done, and you won't have to record this against them. So don't even bother getting this notarized yet. See, a notarized signature is required usually in most counties to record any documents. You have to check with your county recorder to see. And you record, or the county recorder, because you're going to, if need be, well, we'll go into that, but this gets recorded. Let's go into it now. If the J.H. Port debt or its agents, right, show up in court, that would be a lawyer. See, a lawyer is working with them, so that makes them liable. So if the lawyer or J.H. Port debt, right, has any assets, or the owners of J.H. Port debt, right, you can go find out who the owners are of J.H. Port debt on the internet. You can do a Google search and find out who the owners are. And that would be wherever. See, they're in MO, right, Missouri. They're in Missouri, so you go to the Missouri Secretary of State. You look up J.H. Port debt, right, and you look them up. They're going to be listed there. They're going to have officers and so on. And they're going to have names and addresses. Those people have assets. So this can get recorded against as officers. Usually, these debt collectors like this, they don't have assets, but banks do. They have headquarters and branches and so on. And so do, if government's trying to collect, well, they have, parks and buildings and so on. You can go down to the county recorder and record this bill that they agreed to against that property. It's a small fee to do so. It's a short, filing right here. So let's go through it now. The notice of lien is due in the amount of $11,630 at 23.24%. So this amount matches exactly, even if it doesn't in this document right here. If I, for some reason, didn't match this number exactly to the amount that was in the notice and demand for payment, the notice and demand for payment has the exact same amount of money here, the exact same interest rate, okay? The same terms, all right? Whatever was due on the notice and demand for payment, right? Let's see. There we go. On the notice and demand for payment, here it says 20,107, right? So it would be, just to make this all exactly correct, 20,107. Okay? So that's it. That's the amount. It comes off the notice of demand for payment, which comes off of the account you're alleged to owe. That's the third mailing. All right? And that's the whole of it right there. Now we're going to go into the into the fourth mailing. Whoops. Got here. Third. What am I doing here? I'm sorry. I was going to go into a fourth mailing. There's only 3 mailings. What am I talking about? So, okay, this is the step-by-step process. I've shortened it, right? But what do we do next after this, all right? I'm going to go through the steps after this that are not... This paperwork is here to set up the few remaining steps left to go, okay? There are going to be small claims cases after this, and then, as I said, the recording of this. If they don't see what are you gonna do next after these 3 mailings? After this, you're gonna begin the small claims process. And in the past, I had a big write up about how to do the small claims case and so on. Don't even bother with big write up or anything like that. They don't usually pay any attention to that. Although it was all correct, it's just a lot more work for you. Why make more work? That's just not necessary. So, the first small claims case that you're going to do, and I recommend always that you use the application. In Florida, it's called the Application for Determination of Civil Indigent Status. In other states, it can be called a waiver of fees form. It's a form proving that you have no money. Your person, this is the person that's suing, okay? Going to go to small claims. The person has zero income, has zero assets, makes no money, owes no bills, none of those things. It doesn't do it. Doesn't have any. It's all zeros. Has zero income, okay? So that's the truth of it. You set up with a trust first, as I've explained. You take grants into the trust. You no longer take income to the person. Then it's free to file a small claims case against any company, such as JH Port Debt. So you use this, waiver of fees form, or in Florida it's called an Application for Determination of Civil Indigent Status. You simply write zeros everywhere. The person owes no bills, it's zero for income, and it's all zeros for money it has, zeros for assets, zero, 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 zero. And that's very important to do because they'll notice you sued them for free and there's no money that they can get. Zero. So every nickel they spend on lawyers and time and all that is going to get them a $0 return. That's not good return for businesses, so they're likely to quit. So there are going to be 4 separate small claims cases done one at a time. Unless you're in a hurry, like in foreclosure or something, you do all these things, you shorten the timeline, you just do them one after the other, pay no regard for timelines or anything, and you simply do it as fast as you can. That's the way to do it if you're in an acute situation like foreclosure, what have you. You do these all rapidly. You don't worry about the time because the time can tick-tock while you're waiting for your court date at small claims. So, if there's a foreclosure or something, you simply show them the small claims over in the foreclosure and say, hey, I need more time. There's already an action going on. So they're likely to, in all the cases I've seen, they reschedule for a much later date the foreclosure. So anyway, so the next step is 4 individually separate small claims cases, and they don't all go in at once. The idea here is to get them to get an attorney, get them to go spend the money, and each time they'll have to go down there, spend the money. See, an attorney is a lot of money by the hour, and they have to drive down there, prepare the case, all that. Each small claims case costs them at least $5,000, at least that much money. They have to get a retainer, they have to pay the hourly, and so what are these 4 small claims cases? Well, they're very simple. The first one is it's for 33. There's a small section for a statement of claim, okay, in every small claims case. You'll just say this. There are very few words in the statement of claim. And the amount of money for the first one is $33.33. And it goes back to, let me reference what you're going to be doing here. And it's from our first mailing. All right, first one we went over, right? In addition, right here, no presentment or proof of license and or permit to regulate, issue, or collect on the promissory notes of the In God We Trust has been demonstrated. So You write in the small claims where it says statement of claim, acting as an unlicensed uh, regulator, issuer, and collector of In God We Trust promissory notes. Okay? So it comes from that sentence. You asked to see that they were licensed to do this or permitted to do it. Only a license granted by a trustee of the trust would prove that. Okay? So you're asking for that. I've never seen a lender properly licensed in any way, shape, or form. Never seen it. It's never, when I've gone to court, they've never had their license in order. So, ever. And this is a different kind of license you're asking for. You're asking for, because they're operating saying, hey, we can, we're licensed, because in Florida statute 33, and you can look this up. I don't know it's 33 in every state, but Florida statute number 33 XXXIII, right, is about regulation of money, all right? And in that there's a section 516.02, I think, which is about having a license. Every state and every state requires businesses to be licensed, to have a financial entity, right? Like a bank or a lender. You have to have a license. So you're asking for a license. So you use that state statute, you reference it, you say Florida statute 33, and then you use the words, like I said, acting as, right, or operating as an unlicensed regulator, issuer, collector of promissory notes of the In God We Trust. Anything close to that. So you're simply going to go into court and say, show me the license. Show me that the trustee or trustees of the In God We Trust said you can do this. You have a license to collect on their trust notes. That's what you're asking for. They don't want to talk about that. Okay, that's the first one. Now, the second small claims case, and that's all it'll say. You don't have to bring your paperwork with you from your first mailing, and that's what you bring. You see, like, Your Honor, I asked them, and they didn't show the license. So where's that license? So that's $5,000 they dump in the bucket there, at least, just going to court. And then the last time I went to court on a $1,000 FDCPA violation, the other company hired the largest law firm in Florida, Ackerman LLP, and spent at least $50,000 in legal fees to try and fight that $1,000 action. And they still didn't get what they wanted out of it. Okay, and I'm getting them um, off the credit report. I've already gotten them off. So, um, they showed up with a 5-year out of date DBA for their company, a copy, not even an original. I mean, it's such a ludicrous what they show up with paperwork. So, okay, that's what that first one's about. And the second part, the next step is the next small claims case, court case. Again, you'll file it for free using that indigent form, and this one will simply say FDCPA violation, and it'll be for $1,000, and you'll attach whatever piece of paper shows them on an account. In other words, when they responded to your validation, your first mailing, I'm sorry. You will send, strike that. You will send them a copy of and this can say, like, it'll say, I'm sorry, I left one thing out of your filing. It'll say FDCPA violation for, Equifax report, for example, okay? In other words, they're on the Equifax credit report, so you copy it, you put it on the back of that claim, okay? And that's the paperwork. No more than that, just a copy of the account. And then when you go in, for this FDCPA violation, it's $1,000 if they don't validate according to the FDCPA. If they don't give you the proof within 30 days when the debt is owed, they owe $1,000. So go collect the $1,000. Show the judge, see, I sent him a validation letter. Where's my $1,000? That's another $5,000 they have to drop. So, and then and you can do that, one separate one for each credit report they're on. So you could, the idea is unless you're in a sticky time situation like a foreclosure, you want to spread this out over as much time as possible, making them spend as much money as possible on the lawyers they hire. Okay, it's all about bleeding the other ones out through the vampires called lawyers. You pay no lawyer fees, they pay exorbitant lawyer fees, and they get nowhere every time. The lawyer never gets anywhere except for sends them a larger bill trying to explain why they didn't get any further with this account, which they never will. So, so that could be up to 3, you know, FDCPA violation, small claims cases. Okay, so it was the In God We Trust one. Now we moved on to FDCPA violations. Okay, and I say that's, four small claims, but it really could be 3 in that place of 1 there. Okay, because it could be all 3 credit reports. Okay, the next small claims case, and do this after the other one is finished. It costs them more money. That's your goal. Waste more time, waste more money. And see, they don't want to fight after a while. They realize it's just a losing battle. The next small claims will just simply say FCRA violation, $1,000. Fair Credit Reporting Act violation, $1,000. Again, you will simply attach the same copy that you made, right, of the Equifax. Look, see, there's the accounts on the Equifax report. Just that one page where they are on the Equifax. You'll bring in your first mailing, everything you've done up to that point, and you'll bring the original of the credit report they're on for that case. So that, I say one, that's the third small claims case, FCRA, but it could be 3 of them in case, or 2 or 1, in case they're on all 3 credit reports. Okay. The fourth small claims case will be for this. There's always each state has its own version of the Fair Debt Collection Practices Act. So you will reference that state statute, and you will say, if there's a fine included, you have to check. It usually mirrors the Fair Debt Collection Practices Act fine of $1,000, but not always. And so that would be that amount of fine, or which is usually $1,000, reference it, and you say, state statute, Fair Debt Collection Practices Act, State Act, for $1,000, and again, you will put a copy of that account in with that small claims case. Okay, good. So 4 of those, spaced out as much as possible, will cost them a lot of money and expose them to all the things that they shouldn't be doing. Now, first of all, I want to say that with that police report, that should remove the accounts just like that when you send it over to the credit reporting agency. But if it doesn't, you move on to this process, this step, all right? Next, after this step, so that's 4 separate small claims cases. Each one they don't want to go through, spaced out, and, that's the next step after those mailings. Then the next step after that was what I was referenced before, and that is with the notice of lien from the 3rd mailing. Notice of lien, great. There we go. Notice of lien, the $20,000. You'll record that against any assets that they have or the owners have. It could be their home or the lawyer that showed up in court for any of those court cases. See, now they're working with JH Port Debt. They're an agent for them. So their assets are at risk too. That was referenced in the validation letter. Their assets are at risk too. Okay? So So you will record this down at the county level for very little money. You know, it might have to be notarized as well, the signature. So you'll check into that. Then you go record this, and then they get sent a copy of this. This is a bill that is recorded against their assets, against their real estate. They are now they won't be able to go get a loan on that real estate or sell it without paying you off or going to court to try and overturn this notice of lien. A very expensive process for them that costs you very little money. Okay, if this gets recorded, you'll simply, um, and they do what you say, then they'll want you to file a satisfaction of lien. It'll be the same way. You'd simply change the top here to satisfaction of lien instead of notice of lien, and it will say account has been satisfied. That's all it will say. Account satisfied in the amount of, instead of notice of lien is due, it'll say account is satisfied in the amount of, and the rest is the same. Okay, in the amount of 20,000, and that's it. And the rest of it will, this will all get removed, and it will say, you know, satisfaction um, of lien in the amount of da 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 da, and you record it, and that's the end of it. It's satisfied because they removed the account or they paid you the $20,000 or whatever you decided, whatever you negotiated with them. In the end, you don't want this money. You want it off the account, off the credit reports, and they will move it eventually. So, and if they don't, well, then you can use the next process that they use at the county level to collect on their debts. And what is that? It's called foreclosure. That's right. It's the only step that may have, some expense to it, but it will be very inexpensive because even if you have to go through foreclosure, you will use, you know, your indigent status form or waiver of fees form to go through those filings. How do you know how to foreclose? Well, you go down and you copy what's on you copy exactly what they did. See, they have to give notice, public notice, and it's down at the courthouse, and the papers are literally sitting there for free, flying out there in public. So you can go take one off the board, go to a copier, go copy everything that they did on a foreclosure, and simply do the same thing on this piece of property to them for this amount of money, because they agreed in the notice of contract change. They agreed that they owed this amount. So you go collect. And this is the final step in the process because you'll get your money. Okay? If you go through this, you will get this money because you have followed every step that you should have, and they haven't produced any documents that prove that they can collect. Okay? That's the way to remove your debt. This has been extremely successful. Rarely does it have to go past, that police report and sending it to the credit reporting agencies anymore. Um, Even, I've never heard of anyone having to go through all those small claims and have to get to the recording part, except for once or twice. But even then, when they did that, immediately stopped it. Right there, they were willing to negotiate and end the whole problem. This is the new 2017 in July uh, debt removal package. I know it's going to work for all of you. Um, Simply follow the steps, please, okay? Follow the steps. Do this. They're the ones without proof. You're the ones with proof of every step of what you've done. You can do this. Stay with it. Keep with it. You're doing great and you can do this. Thank you for your support. Um, and may God give you good fortune in removing these errant, illegal accounts from your credit report.